I have a squatter living in my property, which is based in a complex. I am in the process of obtaining an eviction order against the illegal occupant. Can the Homeowners Association hold me responsible for the occupant's use of water and electricity whilst he has been in illegal occupation? Surely this is criminal activity against the Homeowners Association and should be carried out by them. Bruno?
Did I get this question? All right. So,
yeah.
Right. Remember, you are a member of the Homeowners Association. Pure and simple. Homeowners Association has no connection whatsoever to the tenants. Short potential of them having filled out some register, so they've got access to, to their estate. They've got no connection, no contract, no obligation, nothing of the sort. Well, okay, let me rephrase that though. There are certain occasions where a tenant, by virtue of driving through their estate or living within their estate, would accept certain rules, to which they bind themselves within their estate. So these would normally be it speeding limitations or noise restrictions, that sort of thing. So there are very general rules that tenants are made aware of. More often than not, they're actually compelled to be made aware of these in the lease agreement itself. So in the lease agreement, in the lease agreement, there would be a provision there for a display or an attachment where all these rules would actually be set out, and the tenant would bind themselves to these rules. So now you've got a set of rules, you've got the Homeowner Association and yourself as a landlord. Most of these rules would be enforceable by you as a landlord against the tenant. So payment of water and lights, you can't just put it on the tenant in the lease agreement and expect the Homeowner Association to go sue the tenant. That remains your responsibility. So membership fees, levies, anything that needs to be paid, you would have to pay it yourself. More often than not, you'd actually find that even the levying of penalties for speeding and noise would go against the owner's account. So even though, yes, there might be a right for the estate to actually reprimand or close close the swimming pool area down and ask the tenant and remove the tenant, the penalties would probably be for the owner's account. So just bear that in mind. You're responsible for the eviction. You're responsible for enforcing the rules of the HOA as against the tenant, and you are entitled to claim any damages that you've suffered due to this enforcement. So if you've been charged the penalty, you're allowed to sue for that. If water and lights, whatever the case is. Insofar as criminal behavior is concerned, I often don't spend a lot of time discussing criminal components, because in cases like this, we're not dealing with like criminal elements, we're dealing with civil law, right? And it starts getting complicated if we start getting academic on what is criminal and what isn't criminal. Where does theft lie? Things like this don't constitute theft. They're in occupation of the property. There was at some point or another some lawful reason for them to be in occupation, and you have civil remedies against them. There is no crime that technically covers this type of situation, that especially payment of water and lights and that sort of thing. There is no criminal offense that can actually be enforced or prosecuted.